In June of 1958, two young people from Caroline County, Virginia, decided to get married. Her name was Mildred Jeter. His name was Richard Loving, and under the laws of Virginia, they could not marry each other in Virginia because she was a Negro woman and he was a white man. So they drove north. They crossed the Potomac, and in the District of Columbia, in a jurisdiction that did not care what colors the state of Virginia had assigned to them, they were married. The Supreme Court opinion, when it finally came 9 years later, would describe what happened that month in a single sentence. The way the court chose to describe them tells you almost everything you need to know about why this case existed at all. In June 1958, two residents of Virginia, Mildred Jeter, a Negro woman, and Richard Loving, a white man, were married in the District of Columbia pursuant to its laws. Two residents of Virginia, a Negro woman, a white man. The court used those words because those words were the entire architecture of the case, not what the Lovings did, not how they lived, the categories the state had assigned to their skin. After the ceremony, they did what anyone in their position would do. They went home. Shortly after their marriage, the Lovings returned to Virginia and established their marital abode in Caroline County. Now, what they had done, by Virginia's lights, was a felony. Virginia's anti-miscegenation statutes did not merely refuse to issue licenses to interracial couples. They made the marriage itself a criminal act. And they made it a criminal act to leave the state, marry elsewhere, and come back. In other words, the law was designed precisely for what Mildred and Richard had just done. The drive to D.C. was anticipated. The license issued under D.C. law was anticipated. The trip home was anticipated. All of it was already on the books as a crime. The clock began to run. 4 months after their marriage, in the fall of 1958, a grand jury in Caroline County met to consider the matter of their marital home. At the October term, 1958, of the Circuit Court of Caroline County, a grand jury issued an indictment charging the Lovings with violating Virginia's ban on interracial marriages. Read that line slowly. The state of Virginia indicted two people for being married to each other, not for hurting anyone, not for stealing, not for anything we would today recognize as harm. The offense, in the eyes of Caroline County, was the racial composition of their household. 3 months later, in the dead of winter, the Lovings appeared in the Caroline County Circuit Court to answer the charge. The date was January 6, 1959. What happened in that courtroom is, in the cold language of the opinion, this. On January 6, 1959, the Lovings pleaded guilty to the charge and were sentenced to 1 year in jail. However, the trial judge suspended the sentence for a period of 25 years on the condition that the Lovings leave the state and not return to Virginia together for 25 years. A year in jail suspended, on the condition that they leave, not just leave for a while, leave for a quarter of a century, and not return together. The two of them separately could come back to Virginia. As a married couple, they were banished. The judge who imposed that sentence, the judge whose words opened this episode, did not consider it merely a matter of state policy. He considered it, by his own statement from the bench, a matter of divine instruction. The races, he said, had been placed on separate continents by God himself. Their being together in Caroline County, Virginia in 1959, he said, was the interference. So the Lovings packed up their lives. They left their home, their families, their fields, their state. And they crossed back over the Potomac, this time not to be married, but to disappear. The Lovings did what the court had ordered them to do. They left. They packed up whatever a young married couple in 1959 packs up when a state has told them they cannot live there together for 25 years, and they went north, across the Potomac, into the District of Columbia, the same jurisdiction whose laws had married them in the first place. The opinion describes this move in a single sentence. The court writes, quote, "After their convictions, the Lovings took up residence in the District of Columbia." That is the whole of it in the official report. One line of procedural history, but think about what that line is doing. It is describing two people who are legally married, legally American, and legally forbidden from being together inside their home state. The geography of their marriage and the geography of their citizenship had been split apart by a judge invoking God. And so for years, this is what their life is. They are residents of the district. They are exiles from Virginia. They have children. They visit family carefully, separately, under the constant weight of a suspended sentence that could be activated by any sheriff who decided to notice them. The 25-year clock was running. Then, in the fall of 1963, something shifted. Civil rights cases were moving through the federal courts. The Lovings, with the help of the American Civil Liberties Union, decided to fight the conviction itself. Not appeal it, the time for that had passed. Attack it. Go back to the same Caroline County courtroom that had banished them and ask the trial judge to vacate the judgment, on the ground that the law he had used was unconstitutional. The opinion reports the filing in the dry voice of procedure. Quote, on November 6, 1963, they filed a motion in the state trial court to vacate the judgment and set aside the sentence on the ground that the statutes which they had violated were repugnant to the 14th Amendment. Repugnant to the 14th Amendment. That is the legal theory in 6 words. The 14th Amendment, ratified in 1868, the one that says no state shall deny to any person within its jurisdiction the equal protection of the laws. The Lovings were arguing, through their lawyers, that a statute which criminalizes a marriage based on the race of the spouses cannot survive that command. They were not asking for mercy. They were asking the law to be honest about itself. And then the motion sat. Months went by. The Virginia trial court did not rule. It did not deny the motion. It did not grant the motion. It simply held it. So in October of 1964, with the state proceeding stalled, the Lovings opened a second front. They filed a class action on behalf of themselves and everyone in their position in the United States District Court for the Eastern District of Virginia. The court summarizes this move tersely, quote, the motion not having been decided by October 28, 1964, the Lovings instituted a class action in the United States District Court for the Eastern District of Virginia. Now consider the rhythm of the constitutional clock here. June 1958, they marry. October 1958, they are indicted. January 1959, they are banished. November 1963, they file to vacate. October 1964, they go federal. That is more than 6 years of being legally married, legally banished, and legally waiting. 6 years is a long time to live inside the gap between what the law says you are and what the law allows you to do. The state trial judge finally ruled on the motion to vacate in January of 1965. He denied it. The Lovings appealed to the highest court in the Commonwealth of Virginia, the Supreme Court of Appeals. And there, in 1966, they ran into the last wall of the state system. The Virginia Supreme Court of Appeals reviewed the anti-miscegenation statutes, the very ones the Lovings said were repugnant to the 14th Amendment, and it did the thing that high state courts in that era often did with laws of this kind. It blessed them. The opinion reports the ruling without comment. Quote, the Supreme Court of Appeals upheld the constitutionality of the anti-miscegenation statutes. The court did modify the sentence slightly. Then it affirmed the convictions. Virginia's position, formalized at the top of its judicial system, was that the state could continue to criminalize the Lovings' marriage, that the trial judge's theology was, at least in its legal effect, the law of the Commonwealth. There was only one place left to go. On December 12, 1966, the United States Supreme Court took the case. The opinion notes the moment in a single procedural line. Quote, we noted probable jurisdiction on December 12, 1966. 8 years after Mildred Jeter and Richard Loving had stood up in a District of Columbia ceremony and become Mildred and Richard Loving, the question of whether their marriage was a crime was on the docket of the highest court in the country. The argument was set for the spring. 1967, the case captioned Loving versus Virginia was argued before the Supreme Court of the United States. The Lovings themselves were not in the courtroom. They were in a small house in King and Queen County, where their 3 children were already in bed by the time the lawyers in Washington stood up to speak. The question the court had agreed to answer was, on its face, a narrow one. Were Virginia's anti-miscegenation statutes consistent with the 14th Amendment? But sitting inside that narrow question was a much larger one. Could a state, in 1967, still claim the power to decide which Americans could marry which other Americans based on the color of their skin? 16 states still claimed exactly that power. The Lovings case was not a relic. It was the present tense of American law. 2 months later, on June 12th, the answer came down. The opinion of the court was delivered by Chief Justice Earl Warren. It was unanimous. 9 justices, 1 voice. Warren walked methodically through Virginia's argument. The state had insisted that its statutes were not racially discriminatory in any meaningful sense because they punished both the white spouse and the black spouse equally. Both went to jail. The state called this, quote, equal application. Warren did not. He noted that Virginia prohibited only those interracial marriages that involved a white person. A marriage between 2 non-white people of different races in Virginia was not a crime. And from that one observation, the whole defense of the statute collapsed. Warren wrote, and I'm quoting directly from the opinion, "The fact that Virginia prohibits only interracial marriages involving white persons demonstrates that the racial classifications must stand on their own justification, as measures designed to maintain white supremacy." White supremacy, capital letters, in a United States Supreme Court opinion. That sentence is the philosophical hinge of the entire decision. Once you name the statute's actual purpose, the constitutional analysis becomes almost mechanical. A law designed to maintain white supremacy cannot be reconciled with a constitutional amendment that was ratified in 1868 for the express purpose of ending exactly that. And so Warren reached the holding on equal protection. He wrote, "There can be no doubt that restricting the freedom to marry solely because of racial classifications violates the central meaning of the Equal Protection Clause." The central meaning, not a peripheral one, not a contested one, not a meaning subject to local custom or regional history. The central meaning. But Warren did not stop there. He could have. Equal protection alone was enough to vacate the convictions. Instead, he turned to the Due Process Clause and folded a second argument into the opinion. Marriage, he said, is not merely a contract that the state happens to license. It is something older and something larger. He wrote, "Marriage is one of the basic civil rights of man, fundamental to our very existence and survival." Consider the weight of that sentence. Marriage, lifted out of the catalog of ordinary state-regulated activities and placed into a small and consequential category. Basic civil rights, fundamental rights, rights that a state may not take away regardless of the procedure it follows in taking them. Justice Potter Stewart wrote a brief concurrence. He joined Warren in full, but he wanted to say one more thing in his own voice on his own terms. He had said it 3 years earlier in a case called McLaughlin versus Florida, and he wanted to say it again. Stewart wrote, "It is simply not possible for a state law to be valid under our Constitution, which makes the criminality of an act depend upon the race of the actor." That is a categorical sentence. It admits no exception.